Yes.
Thank you, my lord. After New Brunswick and Concha, can I take the court to a more recent decision of the Appellate Committee, the Senna, which can be found at page 2598 of the authorities bundle. This is Lord Brandon speaking for the Appellate Committee, and the relevant passage can be found at page 2607, which is page 499 of the law report. And just under letter A, third line, the first matter, he says, is that if an estoppel exists, it's issue estoppel. Second matter is that in order to create an estoppel of that kind, there are three requirements. First is that the judgment in the earlier action relied on must be of a court of competent jurisdiction, it must be final and conclusive, and it must be on the merits. And then he deals with further requirements, and he defines what he means by on the merits just below letter F on the same page. Looking at the matter positively, a decision on the merits is a decision which establishes certain facts as proved or not in dispute, states what are the relevant principles of law applicable to such facts, and this is the point, expresses a conclusion with regard to the effect of applying those principles to the factual situation concerned. And we respectfully submit that what the Court of Appeal was not allowed to do was to seek to identify a principle which was not limited to the facts and circumstances of the case before Mr. Justice Andrew Baker, and extrapolate from his judgment what the Court of Appeal said was the principle that he was finding relating to either all claims or all claims in respect of the 460 tax vouchers. That, we say, is impermissible. And we say that that principle is supported by the authority which is the Fons et Origo of this jurisdiction, which is Henderson and Henderson. And the court has Henderson and Henderson, 1843, at page 1502. And at page 1502, in the judgment for the court of the Vice-Chancellor, Vice-Chancellor Wigram, we see just below, well, it's the final paragraph on the page, 1502, some 10 lines down, there's a new sentence beginning, the plea. Does the court have that? The plea of res judicata. The plea of res judicata applies, except in special cases, not only to points upon which the court was actually required by the parties to form an opinion and pronounce a judgment, but to every point which properly belonged to the subject of the litigation in which the parties exercising reasonable diligence might have brought forward at the time. Now, the second part of that is the modern abuse of process principle. It's the first part, which is the modern issue estoppel principle. And as the court sees, it is put by the Vice-Chancellor as referring to points upon which the court was actually required by the parties to form an opinion and pronounce a judgment. And our essential submission is that Mr. Justice Andrew Baker was not required by the parties to form an opinion on whether any claim by Skat to recover for misrepresentation was caught by the Foreign Revenue Rule, or adopting new GLJ's approach, whether any claim based on the 420 tax vouchers was caught by the Foreign Revenue Rule. That simply wasn't what he was required to determine. So we say our submission is based upon cogent authority and is based on principle. There's one other authority of the Appellate Committee that I should show the Court. We say it supports our approach, but it's heavily relied upon by my friends. It's the Carl Zeiss and Rayner and Keeler case, which is at page 1164. And my friends refer to the speech of Lord Reid and the speech of Lord Wilberforce. And Lord Justice Newey also referred to this authority. Lord Justice Newey said at paragraph 134, I don't ask the Court to turn it up, but he said at paragraph 134 that Lord Reid indicated there was no justification for a distinction between issues of fact and issues of law. So can I show the Court, please, what Lord Reid said about issue estoppel? If, please, the Court would go to page authorities 1227. It starts at 1164. At page 1227, at the bottom of the page, Lord Reid says that Lord Justice Diplock drew a distinction which Lord Reid found difficult to understand. And then this, at the top of 1228, suppose that as an essential step towards the judgment in an earlier case, it was decided that on a particular date A owed B £100, or that on that date A was alive. The first is, or at least probably is, a question of law. The second is a pure question of fact. Are these findings to be treated differently when issue estoppel is pleaded in a later case? And our answer to that is, of course, that is correct. There's no distinction, but that's because the question of law is not an abstract question of law. It's the application of the law to the particular facts and circumstances of the case that's before the court. There's a dispute, did A owe B £100, or a dispute whether on a particular date A was alive. Lord Reid continues, or take marriage. An issue in the earlier case may have been whether there was ever a ceremony, pure question of fact, or it may have been whether the ceremony created a marriage, question of law. I cannot think, says Lord Reid, this would make a difference if in a later case about quite different subject matter, the earlier finding for against marriage was pleaded as creating an issue of estoppel. And again, we have no difficulty with that because it's not a pure issue of law. It's an issue of law that is wedded to the dispute between the parties which needs to be determined in order to resolve that dispute on the pleadings. Where we draw the line is here where the Court of Appeal attribute, rightly or wrongly, to Mr. Justice Andrew Baker a proposition of law which is not confined to the facts and circumstances of the dispute before that judge. I've read 917C to E already, and I also need to show the court, because again the respondent...
So suppose the question was, does this particular religious ceremony amount to a marriage according to English law? They would decide, yes, it does amount to a marriage, or it doesn't amount to a marriage, and that may decide that case for that particular ceremony that took place. And it also decides, as a proposition of law, that any other marriage between any other two people is also not a marriage.
Yes, well, the latter would be caught by the doctrine of precedent, depending on the level at which the judgment was decided. But the reason why the finding that this marriage was or was not valid according to English law binds the parties for the purposes of issue estoppel is because that was the issue before the court. Does this marriage constitute a valid marriage? I say it's as simple as that. If the judge, in deciding such a question, pronounces more widely, it's difficult to think of a practical example in that context, but decides more widely, issue estoppel wouldn't apply, in my submission. In Carl Zeiss, one also needs to look at 913 of Lord Reed's judgment, page 1224, and at E, one sees that Lord Reed cites with approval the Duchess of Kingston's case, which I took the court to in relation to not drawing inferences, and we see that passage at the top of page 1225 at B. There's then a reference, helpfully, to the inhabitants of the township of Hartington case at 1225, just below letter C. And in that case, there was previous litigation where it had been decided that two young children had a settlement in the defendant's township. The issue was which township was responsible for these indigent children. And the question at issue in the case was the settlement, in the new case, was the settlement of their mother. And it was held that the defendants were estopped from denying that she had the same settlement. And the cause of action was not the same, but Mr. Justice Coleridge said the question then is whether the former judgment concludes not merely as to the point actually decided, but as to a matter which it was necessary to decide and which was actually decided as the groundwork of the decision itself, although not then directly the point in issue. Now, it cannot be said that the facts we are considering were merely collateral to the decision in the former case. The question then was where two unemancipated children were settled, and it was answered by showing that they were the legitimate issue of William and Esther, that's the parents. That is, that these two were lawfully married and the children born after, and that William that's the father, was settled with the now appellants, that's the township. Strike either of those facts out, and there's no ground for the decision. These facts, therefore, were necessarily and directly matter of inquiry. The question now is where is Esther settled? And this is answered by showing the same two facts, the marriage of Esther and William and the settlement of William, the two facts already decided. The judgments in the two cases therefore rest on the same foundation, which having been settled in the first cannot be unsettled in the latter. So the first case decided and needed to decide a question of fact as to where the parents were settled and that the children were the lawful, whether they were lawfully married, the parents. And it followed from that as to where the children were settled. And so the same issue arises, the same factual issue arises in the second case. 1226, we see again there's a mention of hoisted, rejected by Lord Roma in New Brunswick, rejected by the Privy Council. Lord Reid confines himself to saying that hoisted is a case which has given rise to some difficulties.
Where are you? At the foot of 1236?
It's E, my lord.
Yes,
1226E, he says that. And we also need to look, perhaps we could just glance at the top of 1226, another case, Flitters and Alfrey, a landlord alleging a weekly tenancy obtained a warrant for the eviction of the tenant, and then he sued him for rent. He failed because the judge held there was a yearly tenancy. The tenant then sued for damages for eviction, and Lord Coleridge, to which he now become, Chief Justice, said the now plaintiff succeeded upon the trial of a plaint in the county court which involved the same question of fact as that which was in issue in this cause, whether his tenancy was a weekly or a yearly tenancy. Counsel pointed out failure to succeed in the action for rent did not on the face of it necessarily involve any decision that tenancy was yearly and not weekly, but that was in fact the ground upon which the county court judge decided the case, and the landlord was not entitled to relitigate that issue in the tenant's subsequent action for damages. So again, it's confined to what is in dispute between the parties in the first set of proceedings. And then we need also to look at Lord Wilberforce's speech, which can be found, the relevant passage can be found at page 1275. And again, I invite the court to note at the bottom of 1275, there's again reference to and approval of the Duchess of Kingston's case on not drawing inferences. Lord Wilberforce says the passage has been quoted by his noble and learned friend Lord Reid. An accepted restatement was given by Coleridge J. in Hartington, and I've referred to that, quoted by Spencer Bower, states the principle as being the judicial decision was or involved a determination of the same question as that sought to be controverted in the litigation in which the estoppel was raised, a formulation which invites the inquiry how what is involved in the decision is to be determined. One way of answering this is to say any determination is involved in the decision if it's a necessary step to the decision or a matter necessary to decide was actually decided as the groundwork of the decision. And from this it follows it's permissible to look not merely at the record of the judgment relied on, reasons for it, the pleadings, the evidence, if necessary, other material. But what it's not, I say, permissible to do is to identify from a judgment that which it was not necessary for the judge to decide in order to resolve the issue before him, and it was not necessary for Mr. Justice Andrew Baker to pronounce on other potential claims, that is, claims not being brought by Skat in the 2019 proceedings. We find in my submission the same approach applied in another case which my friends draw attention to and which we rely upon as well, the High Court of Australia, in particular the judgment of Mr. Justice Dixon in Blair and Curran. And the court will find Blair and Curran at page 2710 of the authorities bundle. What the court was doing in that case was interpreting a clause in a will. And Mr. Justice Street had interpreted that clause some 30 years previously in earlier litigation between the same parties. So on each occasion, the court was applying the relevant law, that is, principles of interpretation, to the facts. Those are the words used in the will in question. So it wasn't a point of law divorced from the factual dispute between the parties. And one sees that at page 2775. This is the judgment of Justice Dixon. In the middle of the page, there's a paragraph, penultimate paragraph on the page, begins, if the matter were res integra, the view which I should be inclined to prefer is that the clause in question amounts to a gift of a particular residue consisting of the assets in Tasmania other than the sweep business and the monies in the bank. And then at the end of that paragraph, but the matter is not res integra, for Street J evidently adopted the contrary interpretation of the clause and held that it caught an interest in the sweep business disposed of invalidly. So that's the context. And what Justice Dixon decided is at the bottom of page 2778, it's page 532 of the law report. There's a reference to Lord Shaw in Hoisted, the judgment which has been disapproved elsewhere. And then this in the final paragraph on 2778, but matters of law or fact which are subsidiary or collateral are not covered by the estoppel. Findings, however deliberate and formal, which concern only evidentiary facts and not ultimate facts, forming the very title to rights, give rise to no preclusion. Decisions upon matters of law which amount to no more than steps in a process of reasoning tending to establish or support the proposition upon which the rights depend, do not estop the parties if the same matters of law arise in subsequent litigation. That's the principle, and it's the principle for which we contend in this case. At its highest, what the Court of Appeal have attributed to Mr. Justice Andrew Baker is a finding of law that is not confined to the very title to rights that were in issue in the proceedings before him, and which amounted to, at best, steps in a process of reasoning tending to establish or support the proposition upon which the rights depend. That's not good enough for issue estoppel. Issue estoppel is confined to what has actually been found in relation to the dispute between the same parties in the earlier proceedings. Justice Dixon also cited with approval what had been said by Mr. Justice Coleridge in The Inhabitants of the Township of Hartington, which I've taken. Well, I haven't taken the court to it directly, but I showed the relevant passages in the Carl Zeiss case. The respondent relies on Blair and Curran. It's paragraph 100 of its written case. As they say, the respondent says that this supports the proposition that Dixon J was applying the ratio of a previous decision in the context of issue estoppel. Well, with respect, we say that is unsustainable given the passage that I've just read from Justice Dixon's judgment. Steps in the process of reasoning are the very substance of the ratio of a judgment, but as Mr. Justice Dixon said, that was not sufficient to establish an issue estoppel. That's the bottom of 2778 and the top of 2779. And indeed, Mr. Justice Dixon expressly distinguished between the ratio of a previous decision and issue estoppel. One sees that at page 2777. In the middle of the page, there's a sentence in the middle of that page. Apart therefore, this is page 2777, apart therefore from any question of issue estoppel, there's much to be said for us taking the course of following the decision of Justice Street as a matter of authority. It's a decision upon a question of interpretation certainly cannot be said to be clearly wrong. To depart from it would cause incongruity. Justice Dixon recognises that there are two distinct questions. One also sees the same approach adopted by the other judges. Chief Justice Latham.
Sorry, just on this, I see it, page 2778 is the reference to the inhabitants of the township
yes.
of Bartington. I mean, I think that would be a case that would be difficult to explain on the basis of the doctrine of precedent, because that's very limited to the particular circumstances of where someone's an inhabitant, even though that involves, excuse me, conclusions of law as to where people were married.
Yes, yes. Well, there's a finding of fact based on the relevant law in the inhabitants of the township, because there's a finding that the parents were settled in a particular township, and there's a finding of mixed law and fact relating to the legitimacy of the children. But plainly, Justice Dixon is not deciding this case on the basis of precedent or suggesting that the ratio of the decision, the earlier decision, determines issue estoppel. And it's important to note in my submission that Chief Justice Latham adopts, who's supported by Justice Stark, at the top of page 2741, it's the third line, it says, independently of any question of estoppel, His Lordship agreed with the decision of Justice Street, and he explains why it should be followed in the rest of that paragraph. Likewise, the decision of Justice Stark at page 2756 to 2757. Indeed, Justice Stark rejects the suggestion that there was an issue estoppel. So, there are many different strands in this. My friends rely on Justice Dixon, and we say that what Justice Dixon said is entirely consistent with the submissions that we are putting before this court in this appeal. I should also show the court the appellate committee decision in Watt and Arshan, which is heavily relied upon by my friends. And one finds Watt at page 2693. Watt against Arshan. This is a race discrimination case. And in particular, the respondent draws attention to the statement of Lord Hoffman, speaking for the appellate committee, at paragraph 31, which is on page 2704. And what Lord Hoffman said at paragraph 31 is this: issue estoppel arises when a court of competent jurisdiction has determined some question of fact or law either in the course of the same litigation, for example as a preliminary point, or in other litigation which raises the same point between the same parties. The question is, therefore, whether the appeal tribunal is a court of competent jurisdiction to determine whether the Labour Party was a qualifying body within the meaning of Section 12. So the issue in Watt and Arthan was whether the industrial tribunal, I think it was an industrial tribunal in those days, yes, but it went on appeal to the Employment Appeal Tribunal, whether it had jurisdiction to decide whether the Labour Party was a qualifying body under Section 12.1 of the Race Relations Act. That is, to hear the complaint of race discrimination. And we see at paragraph 4 on page 2699, the terms of Section 12 of the Race Relations Act is unlawful for an authority or body which can confer an authorization or qualification which is needed for or facilitates engagement in a particular profession or trade to discriminate against a person. And Mr. Arzan's case was that he had been discriminated against on racial grounds because he'd not been selected to represent the Labour Party in local elections. And so the original dispute was whether or not the Labour Party was a body for the purposes of Section 12, which can confer an authorisation or qualification. Was being the local party candidate, did it fall within Section 12.1? And in the earlier proceedings, the Employment Appeal Tribunal had answered that question it had answered that question positively in favour of Mr. Arzan, and the same issue then arose at a later stage in further proceedings. And Lord Hoffman explains this at page 2704, paragraph 32. The jurisdiction, 2704, the jurisdiction of an employment tribunal depends upon whether the facts fall within certain statutory concepts which the Act defines with various degrees of precision. And the relevant one was body which can confer an authorisation or qualification. The decision as to whether the facts found by the tribunal answer to the statutory description is sometimes treated as a question of fact and sometimes as a question of law. In either case, however, the tribunal has jurisdiction to decide the question. I can see no basis for distinguishing between questions which go to jurisdiction and those which do not. Decision that a contract falls outside the jurisdiction of the tribunal because it's for services or for service overseas seems to his lordship just as much a question which goes to the jurisdiction as the question as to whether the Labour Party is within the jurisdiction because it's a qualifying body. Both are decisions of fact or law which are subject to appeal within the competence of the tribunal. And Lord Hoffman said, in his opinion, therefore, the decision that the Labour Party was a qualifying body for the purposes of Section 12 was made by a competent court and is therefore binding upon the parties. Now, we have and he goes on to deal with the special circumstances exception, and I'm going to come to that. So we say we have no difficulty with this case because it is a decision as to the legal consequences of facts. That is, the facts relevant and which were in dispute as to the status of the Labour Party. No doubt the tribunal heard a great deal of evidence about the nature of the Labour Party, how it selected its candidates and similar matters. So it was not a case about what I would call a pure point of law dissociated from what was in dispute between Mr. Arzan and the Labour Party. On the contrary, the earlier decision, which Lord Hoffman said was binding on the parties by way of issue estoppel, the earlier decision concerned the application of the statutory criteria under the Race Relations Act to the circumstances of the Labour Party and Mr. Arzan as a councillor, and that created an issue estoppel, as Lord Hoffman said at paragraph 35 on page 2705. In my opinion, said Lord Hoffman, therefore, the Labour Party is stopped from challenging the ruling that it was a qualifying body and was not entitled to discriminate on racial grounds in its choice of candidates for the council election. And he then went on to find that the lower tribunals were entitled to find that indeed the Labour Party had discriminated against Mr. Arzan.
But how long does, suppose then Mr. Arzan, it says there in paragraph 33 that actually that view was later found to be wrong. But it's, nonetheless, it's an estoppel, the benefit of Mr. Arzan. But suppose then 2 years later he applies to be a councillor in another ward and is rejected. Is the Labour Party, can he then bring a claim for racial discrimination, and the Labour Party is still stopped from contesting that it's a body with a relevant status?
Well, that may depend, in my submission, on what the facts and circumstances are that are presented to the second court. But if the basis of Mr. Arzan's argument 2 years later is the same, as it probably would have to be, because the case doesn't depend upon the characteristics of Mr. Arzan, it depends upon the characteristics of the Labour Party, then in my submission, estoppel would apply. One can envisage, however, that there may be a change in the nature of how the Labour Party selects its candidates that may, I emphasise may, be relevant to the application of Section 12. All I'm saying for the purposes of the present appeal is that this case does not help my friends. And it doesn't help my friends because the issue estoppel, which was established, is based upon the determination of the first tribunal, the EAT, wrongly in fact, but the determination that as between Mr. Arzan and the Labour Party on the issue that was in dispute between them, the very issue that was in dispute between them, does Section 12 apply to the Labour Party, a finding was made. It's true, and my friends emphasise this, that there were second and third complaints made by Mr. Arzan, but there's no suggestion that the relevant facts had in any way changed, that it mattered that Mr. Arzan had brought a second and third complaint, because the issue of the characteristics of the Labour Party, which was the issue being determined, was the same. It hadn't changed over the short period that had operated. So even taking this case at its highest in my submission, it doesn't help the respondent to this appeal. That's how
I'm just on my latest question. I wonder whether actually the topic you're going to cover on your third ground of appeal, that there are special circumstances to let people out of being bound by an issue estoppel, might apply in that sort of case.
Arnold
yes,
type case.
yes.
Yeah.
Well, it's
so the first decision, it's not like an appeal out of time because the first decision was right and they're bound by that. No. But it just is 2 years down the track. Are they really
just to give an indication of the dispute on the third issue, my friends rely, since I've got it open, they rely on what Lord Hoffman says at paragraph 33, the final sentence, The whole point of an issue estoppel on a question of law is that the parties remain bound by an erroneous decision. That's what they rely upon, to which the answer is that Lord Hoffman himself recognises at paragraph 34 in the 6th line, it is true that the severity of this rule is tempered by a discretion to allow the issue to be reopened in subsequent proceedings when there are special circumstances in which it would cause injustice not to do so. See Arnold. And Arnold, of course, as I'll show this court, is a case where the first judge, Mr. Justice Walton, had made an erroneous decision on the construction of a rent review clause, but nevertheless the special circumstances rule was applied, and I'll come to why that was in a very short period of time.
This case also illustrate the point that you make in your written case, that the distinction between law and fact for the purposes of determining various issues, such as the jurisdiction of an appellate tribunal, is not the distinction that we're talking about here.
No. Well, I respectfully agree. That is the point we make, and we maintain that point. This case is very helpful for that purpose. So our submission is that these authorities, and there are many, many authorities, but we say that based on the principles that I sought to identify for the court earlier this morning, we say that there is much authority at high level which supports our approach to the first two issues in this appeal, and that the Court of Appeal accepted, it was Lord Justice Newgee at paragraph 60, which is not disputed by Lord Justice Newey and Lord Justice Popplewell. Lord Justice Newgee's starting point, and indeed it was the basis of the finding made by Mr. Justice Bright, was that the 2022 proceedings are similar to the 2018 proceedings, but they're not the same. They do not raise the same issues as were determined by Mr. Justice Andrew Baker in the 2018 proceedings. And we say that in greatest respect, it is wrong in law once that is the starting point. It was the agreed starting point, and the very strongly held view as a starting point by the Court of Appeal. It is not permissible as a matter of law for the Court of Appeal then to seek to identify from the reasoning of Mr. Justice Andrew Baker what the Court of Appeal says is a principle which can be extracted from his reasoning, which goes wider, much wider, than the dispute between the parties in the 2018 proceedings. And whether you look at the view of Lord Justice Newey, with whom Lord Justice Popplewell agreed, or whether you look at the judgment of Lord Justice Newgee, they have extracted, for the purposes of issue estoppel, a principle which travels wider, we would say much wider, than what Andrew Baker J. had to decide, and what in fact he did decide in the order of the court. And that is true whether you adopt as your principle, as the majority did, that the Foreign Revenue Rule precludes all or any claims for misrepresentation in obtaining refunds pursuant to the withholding tax scheme, or whether you adopt the narrower view adopted by Lord Justice Nugee, that it applies to any claim which seeks to recover refunds under any of the 420 tax vouchers which were the subject of the 2018 proceedings. It doesn't matter which approach you take, because Mr. Justice Andrew Baker was confined by reason of the 2018 proceedings, and indeed, if one looks at his order, he was deciding whether the claim that was made was covered by the Foreign Revenue Rule. And for the reasons I've given, I say it is nothing to the point that one can infer from his judgment how he would have decided a different claim that wasn't, in fact, brought. All that the parties required him to decide was whether the claim that was brought was covered by the Foreign Revenue Rule. And the vice, if I may put it that way respectfully, the vice of the Court of Appeal judgment is that they recognise that the claims 2018 and 2022 were different, and they seek to then identify a broad general principle not confined to the claims before Mr. Justice Andrew Baker, in order to conclude, as they do, that issue estoppel applies. We say that's wrong in law. That's our case on grounds 1 and 2.
Can I just ask the point about the fees that you're recovering, EDF, your claim, the proprietary claim to the fees, was that a claim that was asserted in the 2018 proceedings as well?
I'm going to have to ask. No, it was. I'm told no.
No.
The answer to that is no. Your lady.
Was there any argument in the Court of Appeal in this case that even if the Foreign Revenue Rule caught the claim for to claw back the refund from whoever got it, it couldn't cover the claim for the fees? It all seems to have been dealt with as all or nothing.
Well, it would be very difficult to make that sort of argument, because the whole premise of the issue estoppel argument is that Mr. Justice Andrew Baker was wrong in law, as this court and the Court of Appeal held, in finding that the claim advanced in 2018 was covered by the Foreign Revenue Rule. I'm told you can't have a proprietary claim based on negligence. It needs to be based on fraud. Yes, that may be the answer. So it's only because you're basing your proprietary claim on fraud that you can plead it, and therefore it wasn't pleaded in the 2018 proceedings. And the direct answer to my lady's question, unless I'm told I've missed something, is this wasn't a subject that was debated in the Court of Appeal in these proceedings. Is that right? Yes. That's what I thought. That's the direct answer. But my submission is not surprising. It wasn't. Just before I conclude on grounds 1 and 2...
Can I just ask, I mean, you very much run grounds 1 and 2 together. Are they, in fact, different grounds?
Well, I said in opening that I could see there is a substantial overlap between the two. They are conceptually different, because ground 1 says that you can't have an issue estoppel based on a pure question of law, in other words, in the abstract. But we do accept, and Watt and Arzan is a very good example of it, as are many other cases. Arnold's another case where an issue estoppel is based upon the application by the first court of the law to the facts of the individual case. That's what Watt and Arzan was about. It was the application of Section 12 to the facts of the dispute between Mr. Arzan and the Labour Party. And Arnold, to which we're coming, was a case about the application of the law, that is the principles of interpretation, to the particular rent review clause which Mr. Justice Wharton was interpreting. So I don't want to be understood, if I may say so, as contending that issue estoppel cannot arise in relation to a pronouncement of law on the facts of the case before the court. And the examples given by Lord Reed that I showed this court in Carl Zeiss, similarly, you know, are these parties married? Was there a valid marriage? That's the application of law to the facts. But I do maintain as my ground one, you cannot have as the basis for an issue estoppel what has been called a pure point of law, that is, a point of law that is wider than the application of the law to the facts in dispute in the case before the court. That is ground one. Ground two is similar in that we are contending that the issue estoppel is limited to what was necessary to the first judgment, the earlier judgment. And what is necessary is only that which resolves the dispute on the pleadings, on the issues before the court, or the pleadings before the first court. What needs to be decided in order to resolve the issue before the court. And a good example of that is Concha and Concha, and also New Brunswick. And New Brunswick stands for the first proposition as well, the first ground as well. So they are conceptually different, but I readily accept that there is a substantial overlap between those two grounds, but they are conceptually different.
And your first ground, the difference you're making is we all know that a question of the construction of a contract clause is a question of law, and that's why it's decided again at each appellate level.
Yes.
If it's a question of fact, it's not so amenable to.
No, I readily accept.
That's a different point from you say a pure point of law. Because if you were construing a clause in a standard form contract, for example, somebody who's a party to that contract might be bound by a decision on the construction of that contract by an issue estoppel, whereas lots of other people who have the same contract would not be bound by that if that decision was overturned in a different case.
There's the recent decision of this court, isn't there, that says, I can't remember the name of it, that on a standard form contract, the court would give very substantial precedental value to the decision that it's made, that a court has made on a standard form contract when the parties are different as one would expect. But the reason why that type of issue of law does create an issue estoppel as between the parties is because it is an issue of law that resolves the factual dispute between the parties, and the factual dispute is based on the contract. Here are the facts of the contract we have agreed. What is the proper interpretation? And so the issue estoppel arises because the law is applied by the court, the first court, to the facts of that case. So I readily accept that does create an issue estoppel as between the parties. The only other point, subject to questions that the court may have for me, which I, of course, will seek to answer, the only other point I wanted to make on grounds 1 and 2 is just to show the court, if I may, what the essential difference is between the first claim and the second claim. And I was asked questions about this
Yes, that would be
earlier this morning. It may assist the court just to look at our written case where this is set out and all the references are given. And the differences between the 2018 claim and the 22 claim start on page 34 of the documents. Our written case begins at page 24, and it's page 34 at B2 where we set out the differences. And one of the differences, of course, is that we are now claiming fraud, and we did not claim fraud as against EDFM in the 2018 proceedings. And that's, of course, not a technical matter. It means we have to prove matters not in issue in the earlier proceedings. We have to prove, and we say we can prove, that the defendants knew that the representations were false. And that is a different issue, a fundamentally different issue to the issue that was before Mr. Justice Andrew Baker, as between, for him to determine, as between 2018 and 2022.
Can I just check the way the tax vouchers work? So I'm looking at paragraph 33 of your written case.
Yes.
EDFM prepare fraudulent tax vouchers. Is that for their clients, and then it's the clients that submit them?
Yes. They prepare the vouchers.
So it's not so much a direct representation in the tax voucher by EDFM, but it's, if you like, procuring, knowing that the representations are false, someone else to make those representations.
Well, they prepare the vouchers, which are then
I thought EDFM
submitted.
did warrant that the information was true in the voucher.
Absolutely, yes. It's on behalf of their clients, but it's EDFM. It's a
Skat. So who submits the tax voucher?
Well, it's
Sorry,
EDFM.
it's a small point, but
yes, it's EDFM who, on behalf of their named clients, who submit the tax vouchers, and it is EDFM who make the representations that we say can be found in those claims.
And so, sorry, I just want to get it clear in my mind. So EDFM submit the tax vouchers leading to payment to their clients, not to EDFM itself. Is that right?
I'm not sure whether it's paid directly to the clients. They're paid back. By
the agents.
Yes, EDFM pass on the
You look at page 136 of the bundle. That's paragraph 14 of Lord Justice Nuge's judgment. That's
yes, I see. Sorry.
They confirm that the client was holding the security.
Yes, precisely so.
Specified.
Yes, so they make the representations which we allege are made fraudulently. They know perfectly well.
Yes, and then my question is, do they get paid? I mean, I just want to understand the mechanics. Do they get
Where
paid?
does the refund go to, is your Lordship's question. It goes to EDFM or it goes to the client? Yes, it goes to the client in the first instance. We say as part of the scheme, it then went back to EDFM because that's part of the fraudulent arrangement that is being made. But that's
all right.
That's factual degree that we have to prove. But that's our allegation.
All right, thank you. You were on your written.
No,
case.
I was just going to show the court, if it assists, paragraphs 36 to 38. Because this addresses the question of shares or no shares, which I was asked about. And at 36, we say the bases for alleging falsity of the representations made by the tax vouchers are different as between the 2018 claim and the 2022 claim. And there are two categories. There's non-Annex E tax vouchers, that's 37. And there's Annex E tax vouchers at 38. So if we deal first with the non-Annex E tax vouchers, we say, and this is a summary of the pleading, Skat did not allege in the 2018 claim that the non-Annex E refund applicants did not own the Danish shares or receive the dividends identified in the tax vouchers. Skat's case, that's 2018, was that to the extent that the clients owned Danish shares and received dividends, which was not admitted, EDFM, rather than the clients, was the beneficial owner of such shares and dividends. In respect of the non-Annex E tax vouchers, the key issue in the 2018 claim is whether EDFM, rather than their clients, was the beneficial owner of the relevant dividends.
So was the point that the refund applicants were the kind of entities that were not liable to Danish tax and therefore could get a refund, but EDFM was not one of those entities, and the tax withheld was tax it was liable to pay. That's
why it was significant that EDFM, on the pleaded case, was the beneficial owner and not the EDFM's clients, precisely so. Now, that's what was pleaded in 2018. In 2022, see paragraph sub 2 at the top of page 36, in the 2022 claim, Skat does allege that the trading underlying the non-Annex E tax vouchers did not result in the non-Annex E refund applicants becoming the owners of any shares in or receiving any dividends from the relevant Danish companies. Accordingly, the issue of beneficial ownership does not arise in the 2022 claim. In other words, there were no shares, there were no dividends at all. That's the case.
So does it come to this, that, I mean, we've got the vouchers, we've seen an example, and they're relatively short documents, but I think you're saying that the pleaded misrepresentation contained in those vouchers differs between the 2018 claim and the 2022 claim, much. Even though the words might
in
be
the terms set out. That's the non-Annex E tax voucher. 38 deals with the other category, which is the Annex E tax voucher, and we explain in the 2018 claim, Skat adopted EDFM's admission that the Annex E refund applicants had not received dividends or suffered withholding tax set out in the Annex E tax voucher. However, Skat did not allege that the Annex E refund applicants did not own the Danish shares identified in the tax vouchers. By contrast, we do allege in the current claim that the trades underlying the Annex E tax vouchers involve no real shares in the relevant Danish companies being acquired by the Annex E refund applicants. So it is a different allegation. And the complication...
I suppose in theory, if you were contesting the first of those in the 2018 claim, you could lose on that in actually showing that there was a misrepresentation, but win on the second because, as you say, it's a different misrepresentation. That what makes it a misrepresentation are different underlying facts.
In relation to the substance of the claim. Yes. I mean, none of this, it's not my submission that any of this goes to whether Andrew Baker J, had he had a different formulation of the claim, would have reached a different decision.
I think you've accepted he wouldn't.
I say that's irrelevant. That's my submission. But since your lordships, your ladyships asked the question, I thought it right just to show the court that there are significant distinctions between the nature of the claims in 2018 and the nature of the claims in 2022. But my main point, the fundamental point that I make, is that these claims are different and that Andrew Baker, and they were accepted as different, both by Mr. Justice Bright and the Court of Appeal. And for the Court of Appeal then to extract from Andrew Baker J's judgment a principle that is wider than was needed to address the claim before him by Skat against EDFM is with respect impermissible in order to establish an issue estoppel. That's our case.
And can I just check, is there any substantive difference between the fourth point in paragraphs 36 to 38 of your written case and the fifth? Looking at it very quickly, I'll have to think about it a bit more, but the fifth just seems to be drawing out what's already implicit in the fourth, or have I misunderstood?
No, the fifth is a conclusion based...
right, that's what I rather wondered. The fifth is just conclusory. Is that right?
Is there a difference? What 2, 3 and 4 add? Yes, 2, 3 and 4 on the top of page 37 are not set out in paragraph 37. That is the sellers from whom EDFM's clients purported to purchase the shares, not themselves owning shares. They were naked short sellers. The trades underlying the tax vouchers were circular transactions, and relevant individuals within EDFM knew that the trades underlying tax vouchers involved no shares. They all follow, and they're details of the basic points, certainly, but they are explanations of why we say the fraudulent allegation is correct.
All right, thank you.
So that's what I wanted to say, thank you, Rosalie, on grounds 1 and 2. Can I turn to ground 3, which of course arises if we're wrong on grounds 1 and 2, and it concerns the principle, well-established principle, that the court does have a discretion not to apply the doctrine of issue estoppel if this would cause injustice. And the principle can be found in the speech of Lord Keith for the Appellate Committee in Arnold and NatWest Bank, which is at page 1070 of the authorities bundle. It's Lord Keith speaking for the Appellate Committee, and the relevant passage can be found at page 1086 of the bundle, at the top of page 109 of the law report, page 1006 at the top.
Sorry, 1006, did you?
1006, sorry, 1086, I'm sorry, 1086.
Yes.
1086.
Yes.
At the top of the page, just under letter A, this is Lord Keith for the Appellate Committee. In my opinion, your Lordship should affirm it to be the law that there may be an exception to issue estoppel in the special circumstance that there has become available to a party further material relevant to the correct determination of a point involved in the earlier proceedings, whether or not that point was specifically raised and decided, being material which could not by reasonable diligence have been adduced in those proceedings. One of the purposes of estoppel being to work justice between the parties, it is open to courts to recognise that in special circumstances, inflexible application of it may have the opposite result, as was observed by Lord Upjohn in the passage which I've quoted above from his speech in Carl Zeiss. And that passage is the passage at the bottom of 1084, letter H, where Lord Upjohn said, all estoppels are not odious but must be applied so as to work justice, not injustice. I think the principle of issue estoppel must be applied to the circumstances of the subsequent case with this overriding consideration in mind. And the Arnold case, as the court will recall, concerned a judgment by Mr. Justice Walton on the proper construction of a rent review clause in a lease, and he found against the plaintiff tenants. And Mr. Justice Walton refused to grant a certificate allowing the tenants to appeal the point of law to the Court of Appeal, and so no appeal was possible in that case. And in later cases, the court, between different parties, the Court of Appeal gave judgment which meant that the decision of Mr. Justice Wharton on the construction of this clause was wrong. There was then a later rent review between the same parties, and the plaintiff tenant sought to raise again the same issue of construction under the same lease. And subject to special circumstances, issue estoppel applied. Why did it apply? Well, because between the same parties on the same lease, Mr. Justice Wharton had determined the meaning of that clause. So he'd applied the law to the facts of the case, that is, the terms of the lease. So the issue arose as to whether or not there were special circumstances. And what Lord Keith said, and it's the bottom of page 1087, just above letter H, Lord Keith said that he was in agreement with the passage in the judgment of the Vice-Chancellor, Sir Nicholas Brown-Wilkinson, who had said, in the same case, had said, "In my judgment, a change in the law subsequent to the first decision is capable of bringing the case within the exception to issue estoppel, if, as I think, the yardstick of whether issue estoppel should be held to apply is the justice to the parties, injustice can flow as much from a subsequent change in the law as from the subsequent discovery of new facts. In both cases, the injustice lies in a successful party to the first action being held to have rights which in fact he does not possess. I can therefore see no reason for holding that a subsequent change in the law can never be sufficient to bring the case within the exception. Whether or not such a change does or does not bring the case within the exception must depend on the exact circumstances of each case." So the change in the law in Arnold was simply that in a later case the Court of Appeal had given a ruling which established that Mr. Justice Wharton was wrong in his construction of the relevant rent review clause. Now, the first question that arises today is whether we should be allowed to invoke the special circumstances exception when we did not invoke it before Mr. Justice Bright or in the Court of Appeal hearing. Although we did raise it in our application to the Court of Appeal for permission to appeal to this court, and of course we did raise it in our grounds of appeal to this court.
Sorry. So when you were asking the Court of Appeal for permission to appeal to the Court of Appeal, you raised it
To this
to this court. Oh,
yes,
sorry.
to this
Okay.
court. Yes. Once the Court of Appeal had given its judgment,
Right.
That's when we first raised it in
Yes.
our application to that court, which failed for permission to appeal, and we revived the point when we applied to this court for permission to appeal, and this court gave us permission de bene esse. So I need to deal with this point. Now, I say that the legal principle that governs whether a party should be permitted to raise a new point on appeal was summarised in the Notting Hill finance case, which this court approved in the test claimants in the F11 group litigation case. So can I go to that judgment, F11 group?
FII.
FII, sorry, FII.
Investment Inc.
FII group litigation. And that judgment is at page 2449. Test claimants in FII group litigation 2449. This was a case where this court was divided. My Lord Sales dissented with Lord Briggs and Lord Carnworth, but not, I think, on this question. My Lord will correct me if I'm wrong on that. But
well, I will when I've read it, but I can't remember.
The relevant passage in the judgment of the court is paragraph 90, and your lordships, your ladyship, will find that at page 2505. And this is the judgment of Lord Reid and Lord Hodge for the majority. Page 2505, paragraph 90, in Notting Hill Finance, and we have that if the court wants to see it at page 1870 of the bundle of authorities. In Notting Hill Finance, the Court of Appeal, in a judgment delivered by Mr. Justice Snowden, stated that an appellate court has a general discretion whether to allow a new point to be taken on appeal, and considered and analysed the practice. These authorities show that there is no general rule that a case needs to be, quote, exceptional before a new point will be allowed to be taken on appeal. Whilst an appellate court will always be cautious before allowing a new point to be taken, the decision whether it is just to permit the new point will depend upon an analysis of all the relevant factors. These will include, in particular, the nature of the proceedings which have taken place in the lower court, the nature of the new point, and any prejudice that will be caused to the opposing party if the new point is allowed to be taken. The court, that's the Court of Appeal, then spoke of a spectrum of cases. At one end, where there had been a full trial involving live evidence, and the new point might have changed the course of the evidence or required further factual inquiry, there was likely to be significant prejudice to the opposing party, and the policy arguments in favour of finality would be likely to carry great weight. At the other end, where the point to be taken was a pure point of law, which could be argued on the facts as found by the judge, the appeal court was far more likely to permit the new point to be taken, provided that the other party had had time to meet the new argument and had not suffered any irremediable prejudice in the meantime. Now, we do submit that applying these criteria, this is a case not at the end of the spectrum where there's been a full trial, live evidence, factual issues. It's very much at the other end of the extreme. And we say that this is a case where it would respectfully be appropriate to allow us to argue the special circumstances point first, because it is not necessary to conduct any further factual inquiry before this court can consider the application or non-application of the exception in the present case. The respondent's argument, as I understand it, in response to this is that they say, and it's paragraphs 207 to 210 of their written case, they say an important dimension of whether special circumstances here do apply is they say Skat could reasonably have been expected to appeal Andrew Baker Jay's decision on the Foreign Revenue Rule in the light of Skat's suspicions of fraud at that time. And the respondent says that is a question of fact which Mr. Justice Bright would have decided had special circumstances been argued before him. And our answer to that point is that whatever suspicions Skat may have had about EDFM, Skat had not pleaded fraud against EDFM in the 2018 proceedings, and there's a finding of fact by Mr. Justice Bright that Skat had no proper basis to plead fraud against EDFM until January 2022, which was 9 months after the Foreign Revenue Rule judgment of Mr. Justice Andrew Baker, which was on the 27th of April 2021. And I take, please, the court to Mr. Justice Bright's judgment, which is starts at page 175 of the documents. This is on, of course, issue, estoppel and abuse of process. And the relevant his decision was March 2020. What did I say? Oh, I'm sorry, but his decision was March 20. No? It was April. It was April.
Yes, 27th.
Pardon, March, sorry, but it was April 2021. And if we go, please, in Mr. Justice Bright's judgment at page 190, paragraph 89, this is the finding of fact. It's in the context of abuse of process. 89, he says, I accept all this, but it still follows, in principle, Skat must have appreciated it was in a position to plead fraud within days or at most weeks of Mr. Wade's first report, i.e. within the first few weeks of January 2022. This is when Skat first could have pleaded fraud. So that's the position, and it's unrealistic. And that was upheld by the Court of Appeal at paragraph 109, which is on page 163. If we could go, please, to 163, paragraph 109. This is the Court of Appeal, again on abuse of process. It's said by Lord Justice Nugent, the others agree with him on abuse of process. In these circumstances, I don't think we can conclude that Bright J's decision, Skat first had the material to plead fraud in the first few weeks of January 2022, was wrong or not open to him on the evidence. Now, in the light of that, we say it is unrealistic to suggest that Skat should have appealed Andrew Baker J's decision as to the application of the Foreign Revenue Rule to the negligence claim, in the hope that at some stage in the future it might discover evidence that would entitle it to plead fraud against EDFM.
That assumes that it would be necessary to plead fraud in order to have any prospects of success.
Well, this all arises in the context of whether there are special circumstances relating to the issue estoppel which now arises.
It's to be assumed to arise.
Yeah, and in that context, I say that it's perfectly understandable when Skat did not have evidence on which it could plead fraud, that it thought it took the decision not to appeal in relation to the negligence claim, which would have raised complications that were simply not desirable for it if it wished to succeed in its case. But in any event, we say it is perfectly understandable that the special circumstances argument was not raised before Mr. Justice Bright and the Court of Appeal in these proceedings, when the issue that is said to form the basis of the issue estoppel was not raised by the respondents before either Mr. Justice Bright or in the written arguments in the Court of Appeal. This court has seen that what is now said to be the issue estoppel was raised for the first time in the oral argument in the Court of Appeal. And indeed it was raised, with great respect, not by my friend, it was raised by the court itself, who put to my friend what the court sought to identify as the issue estoppel. So I say it's a bit hard.
That's the reformulation
Yes.
of the preliminary
Yes.
issue.
Yes. And indeed, Mr. Justice Bright had formed a very strong view, which the Court of Appeal agreed with, that on the formulation of the issue,
It was an open goal.
it was an open goal, whatever language they use. So it's not entirely surprising, indeed it's entirely unsurprising, in my submission, that Skat did not seek to raise special circumstances in relation to a formulation of the supposed issue estoppel, which itself was only presented to it and successfully presented to it during the argument before the Court of Appeal. And as I've said, once the judgment was given against us in the application for permission to appeal from the Court of Appeal, we did raise special circumstances. So I say that it would be, with great respect, unjust to say to Skat, you can't now rely on a special circumstances formulation, which may or may not be a good point, I'm coming to that, but you can't raise it when you didn't raise it at a time when the issue estoppel formulation was a bad one, in the view of both Mr. Justice Bright and the Court of Appeal, and the first time you knew what the case against you was as to the formulation was in the oral argument in the Court of Appeal.
And can I just check, are you also saying that in view of the Henderson and Henderson abuse argument, there was a sufficient investigation of facts relevant to your special circumstances argument?
Very much so. Yes, the Court of Appeal considered all of the detailed arguments as to
Didn't
whether...
Mr. Justice Bright do it as well?
Yes, well, it was before Mr. Justice Bright. There was an extensive analysis with argument presented on both sides as to whether for Skat in 2022 to have, as it were, another go was an abusive process. And part of the argument in relation to that went to the circumstances in which the fraud evidence that Skat relies on was obtained, that Skat hadn't appealed Mr. Justice Andrew Baker's decision. All of that was gone into, and the finding by Mr. Justice Bright was no abusive process, and as I've shown the Court of Appeal said either he was right, or at the very least there was no basis for interfering with his judgment. So all of that, we say, militates very strongly against saying to Skat, you can't now raise this point of special circumstances, nor do we accept that there's any prejudice to my friend in having to meet this point now. They've had ample warning of the point, and be it a good point or a bad point, they're perfectly capable, as they've done in their written case, of advancing what they want to say about it. So what do we say, if the court's with me, and if the court is prepared to consider special circumstances, what do we say are the special circumstances here? Well, the starting point, and I accept it's not of itself an answer, but it's a very strong starting point, is that in the light of the judgments of the Court of Appeal and this court on appeal from the judgment of Mr. Justice Andrew Baker, his lordship's analysis of the scope of the Foreign Revenue Rule in his Revenue Rule judgment was incorrect. And that's common ground, there's no dispute about it. Of course, there couldn't be any dispute about it. And it follows from that that the consequence of applying issue estoppel to this case would be to provide EDFM with a Foreign Revenue Rule defence to which it's not entitled on the true state of the law. And I entirely accept that that is the purpose of issue estoppel, but it is a very strong factor to be taken into account in relation to special circumstances, as the Vice-Chancellor, Nicholas Brown-Wilkinson, recognised in Arnold, approved by Lord Keith, and the passage I read at pages 110 to 11 of the law report, and it is starts at page 1070.
I think it was 1086 to 1088 was the bit that you showed us.
Just remind myself. 1087. Passage.
I mean, I think you did show us this passage. I'm not sure that we need to do it again.
The passage in which Sir Nicholas Brown-Wilkinson, bottom of 1087 over to 1088, and I won't read it again, but he recognises that the justice of the matter should take that into account. The second point that, and I should draw the court's attention in this respect to the judgment of Judge Lewis A. Kaplan in the United States District Court for the Southern District of New York in related proceedings brought by Skat in that court. My Lord Lloyd Jones will recall that on the previous appeal there was reference to decisions by Justice Lewis A. Kaplan, is a very senior judge of the US District Court for the Southern District of New York. He's pronounced on this matter of issue estoppel. I don't say, of course, this is binding on this court, but the court may just wish to note that at page 2840 of the authorities, we do have his judgment on the similar proceedings in the United States District Court. It's his memorandum opinion, November 2023, where he declined to accept there was an estoppel that was said to arise from the revenue rule judgment. If we look, please, at...
Is this really going to help? I mean, issue estoppel is a very technical area of English law.
It's a very technical area, but it is the claim against
New York law?
ED and FM. It's the same claim.
Right. Is it the same law is my question?
No, that is true. But can I just take it very quickly in those circumstances? It's at page 2866. He's dealing with collateral estoppel. In the first new paragraph, defendants argue Skat's claim against ED&F are collaterally stopped by the English court's dismissal of Skat's claims against ED&F pursuant to England's version of the revenue rule. He then sets out the circumstances in which collateral estoppel must apply, and they're very similar to our issue estoppel. The issue must be identical. The issue must have been decided in a final judgment, competently, fully and previously litigated. The party against whom the collateral estoppel is invoked must have been either a party or privy to a party in the previous action, etc., etc. And then over the page, 2867, the third line, application of the doctrine of collateral established, estoppel may be unwarranted in circumstances where its purposes would not be served. Courts then must carefully consider whether granting preclusive effect to a prior decision is appropriate. And then in the final paragraph, even if the issues were identical, the circumstances here would counsel against application of collateral establishment estoppel. Justice Baker's decision was overruled on appeal, albeit with respect to defendants other than EDFF, only because Skat chose not to appeal in relation to ED&F. And then at page 2868, third line, given that these appellate decisions overturned Justice Baker's analysis and decision, notwithstanding that Skat did not appeal that ruling as applied to ED&F, granting preclusive effect in those circumstances would be inappropriate. That's all I wanted to draw attention to. The second point that I wanted to raise is again, we say, that Skat was unable to appeal against the broad statement of principle which the Court of Appeal has sought to derive from the judgment of Mr. Justice Andrew Baker. Skat, of course, could have appealed against the determination based upon the order in relation to that which was determined as between the parties in the 2019 proceedings, but Skat could not have appealed the broad statement of principle travelling wider than the circumstances of the litigation in 2019 between Skat and EDFM for the reasons I've already given, referring to Lord Justice Coulson's judgment for the Court of Appeal in Anwar, authorities page 1030 at paragraph 17.
So is this the point that if they had been prepared to accept Skat, as they have accepted, that the negligent misrepresentation claim is covered by the Foreign Revenue Rule, if they tried to challenge Mr. Justice Andrew Baker's judgment in the Court of Appeal and said, we accept the judgment as it goes for negligent misrepresentation claims, but we want to appeal it insofar as it also bars fraud claims, which we might want to bring, the Court of Appeal would have said, well, it doesn't decide anything about fraud claims, so you can't appeal that. Is that broadly what you say?
Yeah, that's the first part of the submission. The second part of the submission is that if we had sought to appeal in relation to the negligence claim, the Court of Appeal would not have entertained a submission, and should not have entertained a submission, that Mr. Justice Andrew Baker was wrong in his application of the Foreign Revenue Rule to issues that did not arise as between Skat and EDFM. That's the submission, and that's because of the general principle. Perhaps I could just show the Court the general principle at authorities page.
Isn't it that you can't attack the reasoning? You can attack the decision.
Yes.
You can't attack the
appeals are against orders, not reasons.
It's lake and lake, isn't it?
That's all that Lord Justice Coulson says. I mean, in my submission, it's a basic principle. Perhaps I could just show you, because it is the authority. It's page 1030 in the authorities volume, and it's at it's at page 1036, paragraph 17, which encapsulates what's being put to me by my Lord Sales and my Lady Simler, paragraph 17, and indeed my Lady Rose. What is much more important, as is page 1036, paragraph 17, Lord Justice Coulson for the Court of Appeal, is that however it may be labelled, an appeal can only lie against something which has been decided, a result, a conclusion, an outcome. It does not lie against any observation or comment by the judge along the way to that result. And then further down, it's only the result that matters for the purposes of an appeal. And that's relevant, say highly relevant, to special circumstances if, contrary to my submissions, the court is going to say that an issue estoppel is established by the broad principle which can be derived, says the Court of Appeal, from Mr. Justice Andrew Baker's determination. So that's the second point. The third point is one that my Lord Sales has already put to me. The public interest underlying issue estoppel and abuse of process is similar. It's not precisely the same, but it is similar. One sees this from Virgin Atlantic, which is at page 2643. The authority starts at 2643, and the relevant paragraph I just wanted to show the court is paragraph 25, which is on page 2668, letter C, where Lord Sumption, speaking for this court, says res judicata, this is page 2668, res judicata and abuse of process are juridically very different. Res judicata is a rule of substantive law, while abuse of process is a concept which informs the exercise of the court's procedural powers. In my view, they are distinct, though overlapping legal principles, with the common underlying purpose of limiting abusive and duplicative litigation. That purpose makes it necessary to qualify the absolute character of both cause of action estoppel and issue estoppel, where the conduct is not abusive. Estoppel, and there's a reference to Lord Keith in Arnold. So there is a similar public policy purpose here, and we do say that in circumstances where both Mr. Justice Bright and the Court of Appeal have rejected the suggestion that Skat has acted abusively, an abusive process, that is highly relevant to whether there are special circumstances which would entitle the court to apply its discretion in relation to special circumstances. I'm not saying that the mere fact there's no abusive process determines the matter in all cases. I'm saying it's a highly relevant factor going to discretion. And the fourth matter that I draw attention to, although the court may think this is of less weight, but it's of some weight, I say, is that the claim Skat wishes to bring in these proceedings does allege serious financial fraud. And Mr. Justice Bright addressed that in his judgment. Back to Mr. Justice Bright. His judgment begins at page 175, and the relevant paragraph is paragraph 123. And it's at page 194 of the bundle. It's in his conclusion. At 123, where he's summing up, he says, "It also seems to me relevant that the case Skat wishes to bring is one of fraud. The general interests of justice, the wider interests of society as a whole, are not well served if serious financial fraud is not brought to light. If fraud has been committed, the fraudster should be exposed." I say that's a relevant factor.
Well, isn't that rather knocked out by the fact that all the claims have been dismissed last October?
Well, they're subject to appeal. The Court of Appeal has decided, Lord Justice Popplewell has decided, that there are properly arguable grounds for contending that Mr. Justice Andrew Baker got it wrong. And in my respectful submission, the Court cannot proceed on the basis that there is no fraud here. It equally cannot proceed on the basis there is fraud here. The Court, in my submission, should proceed on the basis that there are properly arguable grounds that there is fraud and properly arguable grounds that Mr. Justice Andrew Baker erred in finding against Skat on the substantive proceedings. But the principle that Mr. Justice Bright expressed holds true. There is a strong public interest in the allegation of fraud being heard and determined by the court on its merits. And if the respondent is right, the claimant Skat will be unable to ventilate its complaint that it is the victim of serious fraud as against EDFM because of a judgment of Mr. Justice Andrew Baker, I mean the first judgment, which is undoubtedly wrong. And all of that, I say, goes very strongly to the question whether this court should say, whatever its conclusion on grounds 1 and 2, which of course I maintain, but on the assumption I haven't persuaded the court, I say that there's a very strong case here for saying there are special circumstances and that the issue estoppel principle should not be applied because the justice of the case, by reference to all the factors that I've sought to draw attention to, militates against that.
In any event, the trial that's been resolved by Andrew Baker Jay's recent judgment didn't concern the EDFM allegations at all.
Not at all.
They didn't form part of it.
Absolutely. And for all this court knows, for all I know, because I wasn't involved in that, for all I know, for all the court knows, the issues of fact may be completely different. Obviously, there's an overlap, but it should not be assumed that the decision that's made by the Court of Appeal on the substance of the case will necessarily determine the factual complaint of fraud as against EDFM. I should also draw attention...
just to catch up with the Court of Appeal in relation to paragraph 123 of Ms Justice Bright's judgment, I think it's fair to say that Lord Justice Newgee essentially endorses the relevance of taking that into account. This is at paragraphs 120 to 121, page 165.
Your Lordship. Can I just look at that?
You refer this to Mr Justice Bright. I just wanted to complete
No, I'm very grateful to your Lordship. Well, indeed, this was principally because this is paragraph 120 on page 165. This was principally because the court must be cautious about shutting litigants out of their right to justice, but also because the claim was one of fraud, and the general interests of justice and the wider interests of society as a whole are not well served if serious financial fraud is not brought to light. And his Lordship says this is a paradigm example of a broad merits-based assessment. This is in the context of abusive process, of course, but I respectfully rely on that, and I'm very grateful to your Lordship for drawing that to our attention. I mean, it's an old principle of law. Fraud unravels everything, and I don't need to go that far. I'm not suggesting that fraud unravels everything. Fraud is clearly a special case, and it is something that the courts are particularly concerned to ensure are not prevented from being litigated. I just mentioned, I think, one other matter on the special circumstances jurisdiction, because my friends draw attention to the fact, it's paragraphs 222 to 228 of their written case, that the Singapore Court of Appeal has adopted its own approach to special circumstances, and it has said that there are defined criteria, 5 of them they set out, that must be satisfied before the special circumstances exception can apply. It's page 3017. I don't ask the court to turn it up, especially at this hour. Page 3017, and it's paragraph 190 of the Royal Bank of Scotland case. And our response, with respect, is that it would be wrong in principle for English law to confine the special circumstances exception in such a way, that is, defined criteria must be met. We say whether there are special circumstances must depend on all the circumstances of the individual case, not on whether particular preordained factors can be established. And the approach of the Singapore court is, with respect, the negation of the very principle which Lord Keith articulated in Arnold, page 1086, page 109b of the law report, and I repeat it, one of the purposes of estoppel being to work justice between the parties, it's open to the courts to recognise that in special circumstances, inflexible application of it may have the opposite result. That's the issue for the court. Would this work in justice, or would it not? And the court will form a view, if it has to, on issue 3, in light of the factors that I've drawn attention to and any submissions that my friend makes on this question. So that's what I say on issue 3. I'm 10 minutes early, but that's what I want to say to the court on this appeal. We invite the court to allow the appeal on one or more of the grounds that we have sought to identify.
Thank you very much. You don't have any other questions? Mr. Matt.
My lords, my ladies, may I begin by stating as shortly as I can what this appeal is about. It's about finality. In the Revenue Rule trial, Mr. Justice Andrew Baker was required to decide whether Skat's claims were admissible in the English courts under Dicey Rule 3, now Rule 20, and critically why. He decided that question. Skat chose not to appeal that ruling as against my client's EDFM. This appeal we submit is an attempt to reopen that concluded determination, not by appeal, but by reformulation, not by pointing to any change in the facts material to admissibility, but by advancing a new set of claims said not to attract the legal characterization that compelled dismissal before. Although the judge was dealing with the claims as pleaded, their dismissal depended on the resolution of a single anterior issue that applied across the board, and that issue was identified in the Court of Appeal below, whether one looks at paragraph 62 or 131, which was do private law claims to recover Danish withholding tax refunds paid out by Skat based on applications conveying misinformation amount to enforcement of a foreign revenue law. That issue we submit was not incidental. It was necessary. Without deciding it, the claims could not rationally have been dismissed. The reason the learned judge, Mr. Justice Andrew Baker, did not descend into the detail of individual causes of action is straightforward. Inadmissibility is a defense. It bars the claim altogether. It is not concerned with whether the elements of any particular cause of action are satisfied. That is irrelevant. From the perspective of the foreign revenue law, every claim stood or fell together. For that reason, the revenue rule inquiry necessarily operates at a higher level of abstraction than the pleaded causes of action. It asks what the claim is in substance seeking to achieve, not whether any particular private law cause of action is made out. The new claim can only succeed by contradicting that admissibility characterization. Issue estoppel exists to prevent a party from reopening an issue that was necessarily decided even if the earlier decision is said to be wrong. Skat made a forensic choice not to appeal that ruling. That choice now binds it. So, my Lord, the structure in terms of how I intend to proceed is first to address what Mr. Justice Andrew Baker actually decided, and I'm going to spend some time on that because we submit it's important. Then I will turn to ground two, which we summarize as the avoiding the operation of issue estoppel, and then we'll deal finally with the latecomers to this hearing, pure point of law, and then the question of special circumstances, because as you've already noted, pure point of law came up for the first time on the second day of the Court of Appeal hearing. It had never been raised before, and of course special circumstances, as we've just heard, came up for the first time in this court.
But pure point of law wouldn't have come up earlier because it related to the broader formulation by the Court of Appeal of the issue that you had formulated.
My lady, with respect, that's incorrect.
Oh.
It's incorrect. The pure point of law point came up in the context of Mr. Justice, Lord Justice Newgee, on day one, raising this question of a pure issue of law, referring to Spencer Bauer, because when you look at Spencer Bauer, there's a reference to pure point of law, simply one sentence,
yes,
and a reference to an Indian case. And it was on day two that we looked at that particular point of pure point of law. So the pure point of law issue is essentially the issue of whether or not you can have an issue estoppel arising out of a point of law which is effectively untethered to any facts at all. And that's how it arises.
Yes.
I'm not taking any point about time, but it is wrong to say that the reformulation in terms of the issue was the reason for it coming up then. In fact, as I will show, my submissions have been entirely consistent with the question before this court being essentially a question of admissibility. And that is the fundamental point that will be coming through, or one of them, in terms of my submission. Because if one looks at this as an issue about admissibility, the individual causes of action do not matter at all. And one of the points that we're going to be looking at when we look at Mr. Justice Andrew Baker's decision before is that there is a constant theme that the question of the individual causes of action are irrelevant. It's a characterization of the revenue rule on how it operates, which is concerned with the Danish state's interest in what it is doing by way of refund based on these based on the misinformation. The issue of estoppel in this case, unlike many of the other cases, is not operating at the level of causes of action. It is not saying, well, you've decided this cause of action in negligence, therefore you can't, this doesn't apply to a cause of action in fraud. The investigation is an investigation about admissibility, whether the English court will hear this case at all. So arguments about, well, as we've just heard, special circumstances, we must punish fraudsters and we must pursue fraudsters. Nothing that this court has done has said anything about the underlying cause of action. All it's saying is that you cannot bring this claim in England because of the revenue rule. It's saying nothing about the cause of action as to whether you can bring it somewhere else or whatever. The cause of action is unaffected. So the point that I will be making, and we will look at analogous situations where, like the Senna cases about sovereign immunity, I mean, for example, as to whether or not how admissibility operates in that. So, for example, if you've got a state and a claimant of the state was defended on the basis that there was an immunity in contract, you couldn't then say, well, we've now formulated a fraud claim, we want to re-argue the point. The point is that the immunity operates across the board. And the point that I will be making when we look to see, what is in play here is that we have a rule, which is all about admissibility. The investigation was all about characterization, and as we will look to see the way that Mr. Justice Andrew Baker looked at it, this has got absolutely nothing to do with individual causes of action. It makes absolutely no distinction whether there's a cause of action in negligence or a cause of action in fraud. It is not open to say, well, it's inadmissible as a matter of negligence, but fraud is somehow different. That is not the law, and in fact, as this court, the decision, we can look at it, but there is nothing in that decision that reflects the fact that the nature of the cause of action affects the question about whether or not Rule 3 applies or not.
Sorry, when you say decision of this court, you mean the judgment, so on the operation of Dice. Yes, okay.
So that's a sort of a theme, if I may say, in terms of admissibility. And what is going to be the focus. So my learned friend was able to get through his very skillful submissions without making any reference to the decision below of Mr. Justice Andrew Baker. We submit it's absolutely fundamental, because if you look at the judgment, we will see what he was doing. He was applying legal principle. He was applying legal principle to facts. He made the point that there's no distinction between the various claims, no distinction between the various parties. And when one looks at the judgment, as we will do, and tomorrow, I anticipate, we will see what the reasoning is. But the reasoning that comes out of that is that, yes, this is about private law, causes of action. The specific ones do not matter. It's about recoupment of Danish tax scheme based on misinformation, and that's what triggers the rule. What triggers the rule and bases its application has got nothing to do with the question of what the causes of action. He goes out of his way many, many times, and we submit correctly to say that the individual causes of action are are effectively irrelevant for this question of characterization. There's no distinction between any of the claims. There's no distinction between any of the defendants. There was a throwaway passage about identity type cases, but that didn't apply. And no one was ever suggesting, well, this defendant's going to get out, but not this defendant, or that this cause of action operates in a particular way, but a claim in fraud operates differently. So, that's a theme anyway, and I'll develop it by looking at the judgment below.
Certainly. Well, I think, Mr. Mallock, we can say you've heralded your theme very forcefully. I think that may be an appropriate point at which we break for today, and we'll resume at 10:30. Thank you very much.